Juris Vodcast with Scott Pearce.
A bitterly divided Supreme Court just gave federal law enforcement a license to steal in a case called Ali versus Federal Bureau of Prisons. This case interprets the Federal Tort Claims Act, which sets forth federal employees' liability for damages. Usually, federal employees are not immune from civil suit when they cause damage, but there are many exceptions that establish immunity in specific situations. Mr. Ali is a federal prisoner. When he was transferred from one prison to another, personal and religious items, including 2 copies of the Quran, were taken out of his bags. Mr. Ali sued for $177, the value of the property. The Department of Prisons claimed immunity from suit, taking the position that all federal law enforcement employees are free to mishandle, lose, or even steal the property of prisoners or anybody else. Remember when President Clinton debated the meaning of the word is? In this decision, the justices debate the meaning of the word any. Here's the language the justices struggled with. The exemption from tort liability at issue in the case provides that any officer of customs or excise or any other law enforcement officer will be immune from suit for any claim arising in respect of the assessment or collection of any tax or customs duty or the detention of any goods, merchandise, or other property. The question presented was, did Congress mean to confer blanket immunity for property-related offenses on the part of any federal law enforcement officer? Or was the immunity limited to officers engaged in tax or customs work? 11 federal circuits of appeals examined the issue. 6 had interpreted the exception as applying broadly to all officers, and 5 had read it narrowly to apply only to property seizures connected to revenue or customs enforcement. The majority opinion by Justice Thomas chose blanket immunity for federal law enforcement. Thomas wrote that when Congress enacted the law in 1946, it could easily have written any other law enforcement officer acting in a customs or excise capacity. Justice Kennedy wrote a dissent that was signed by Stevens, Souter, and Breyer. In the court's last term, Justice Kennedy voted with the majority in all 24 of the 5-4 decisions. This time around, Justice Ginsburg was the swing vote. Justice Kennedy said that a single word must not be read in isolation, but instead defined by reference to its statutory context. Kennedy argues that the majority had mistakenly focused on the word any in the phrase any other law enforcement officer, when it was obvious from the context that Congress was discussing only customs and revenue seizures. This case is troubling in 2 respects. First, it seems to me that giving this sort of blank check to law enforcement is unwise, because unaccountable authority tends to behave badly. Secondly, the underlying facts of this case fit a worrying pattern. The plaintiff in this case was a Muslim prisoner. Law enforcement officers took away his religious property and some sentimental possessions, and with this Supreme Court decision, we find that they did so with impunity. From our prison camps in Iraq and Guantanamo to this case, and in many other incidents in jails and prisons across America, Muslims are being abused and their religion is being disrespected aggressively. Count me with the millions of Americans who decry this religious discrimination and intolerance, and count me with those who feel law enforcement needs to be more, not less, responsible. For JurisVodcast.com, this is Scott Pearce. Thanks for your attention.
Juris Vodcast is a production of Nuclear Podcasting. Creative Commons Attribution Non-Commercial No Derivatives.